Hey everybody, welcome back. I hope you all are doing great. So this side CS Tanya Bhandari and we have started our EBCL fast track batch in complete English, right? So today we would be starting with another new chapter, that is chapter number 16, which talks about Transfer of Property Act 1882. In short, we call it as TOPA, T-O-P-A, Transfer of Property Act, right? Now, property, in when we hear the word property, we know that it has been bifurcated into two segments. First is movable property and the other is immovable property. I don't have to go more detailed into the what is movable, what is immovable. We all know that something which can be taken to places is movable thing, right? And the thing which is attached to the land or fixed in the land is immovable property. So in Transfer of Property Act, both kind of property, as in the movable and immovable, both are covered. But again, the major focus is primarily on the immovable property side, right? So we would be dealing everything in regards to sale. Also, we would study on the later part lease, mortgage, right? Charge, actionable claim. We will cover all these topics, but major focus has been given to the immovable property. Correct? So let's start this chapter. So it has been written that the law relating to transfer of property is governed by the Transfer of Property Act. If I own a property and I want to transfer it to some other person, right? So what law I have to refer to? I have to refer the Transfer of Property Act. Accordingly, I can transfer the particular property to another person. So the scope of the act is limited as it confines to inter vivos transfer. That means here it is written that again when we talk about transfer of property. Now property we understood it is movable or either the immovable property. Now what about transfer? Transfer also has been bifurcated, as in transfer either can take place by the act of parties, right? That means two parties are involved in a particular transaction, and a particular property is being transferred from one person to the other person. First thing is that other kind of transfer can be taken place by the operation of law. That means the court has given a decision, and in regards to that decision, we are transferring the property from one person to another. Now, court is not regarded as obviously a natural person. Court is not a natural person, correct? So anything, any transfer, in which is happening by the operation of law, as in a will, right? In that no living persons are involved. A person after his death has written, okay, after my death certain property would be transferred to so and so person, so that person is not not alive anymore, correct? So those kind of transfers which are to take effect by the operation of law, as in insolvency, correct, succession, these are not governed by Transfer of Property Act. So Transfer of Property Act, governs only those kind of transfers which takes place between the two living persons. That means the natural persons, living persons, right? So if a transfer is being, taking place between you and me, correct? You are also living and I am also living, right? So that particular transaction is governed under the Transfer of Property Act, and that is known as inter vivos transfer. So inter vivos transfer takes effect between the two living persons, correct? So again, transfer of property, whether immovable or movable, and we will cover everything regards to sale, mortgage, lease, exchange, gift, or actionable claim. Now let's study some important definition. First is revision and remainder. Now listen to me very carefully. I'll in a very layman language we will understand what do you mean by first reversion. Reversion, you can call it as in a layman language just for your understanding, as a kind of revert, right? That means if I suppose I messaged you, correct, and asking you something, or we are having a conversation, correct? So if I am sending you a message, and after reading that you will revert on that, that means you will reply back to me. So the message was originated by me, and as a reply it is coming back to me. Correct? If I throw a ball and there is a wall, okay, right? If I throw a ball on the wall and it will bounce back to me, it is reverting to me, coming back to the original place from where it has been thrown, right? So that is reversion. Correct? Write it down in the bracket as revert. That means if I has a property, correct, and I am transferring to, say, suppose a person named as Mr. Sham. So what I am doing is I am transferring him for a certain period, and say suppose till his life, right? After that certain time, after that particular thing, the property will revert back to me, right? It is reversion, coming back to me, reverting to me, that is reversion, right? So a reversion is the residue of the original interest which is left after the grantor has granted a lessee a small estate. For example, a, the owner of a land may lease it to B for a period of 5 years, right? A is having a land and he is leasing it to B for a period of 5 years. So the person who grants the lease, we all know that person is known as the lessor, and the person who takes the land on lease is the lessee. So here after the period of 5 years, the lessee will come, the lease will come to an end, and the property reverts back to the lessor, coming back to its original owner, correct? So the property which reverts back to him is called the reversion or the reversionary interest. The grantor has a larger and absolute interest out of which he carves out a smaller estate and gives to the grantor, that is the lessee. When the owner, first thing is clear, what is reversion? That if I own a land and I am giving it on lease for a certain duration, after that duration expires, that particular property will come back to me. It will revert, after a certain period it will come back to me. That is reversion, right? Coming back to the original owner. Now, what do you understand by remainder? Remainder is, things, remaining with the other party, right? It is opposite of reversion, not coming back to the original owner, but to a person to whom the original owner has, vested that particular interest on, correct? So when the owner of the property grants a limited interest in the favor of a person or persons and gives the remaining to the other, it calls the remainder. That other person is ultimately getting the property, correct? So the original owner is not getting back, but he's ultimately transferring, and the person who gets the transfer at last, right? So he becomes the absolute owner of that property, and the property remains with the remainder. Write it down for your better understanding that in remainder, the property remains with the remainder, or remains with the other person, not the owner. It does not come back to the owner. So, for instance, A, the owner of land, transfers the property to B for life and then to C absolutely. So, here the interest in the favor of B is a limited interest, that is, it is only for life. When after his life gets expired, so long as A is alive, he enjoys the property. He has limited rights since he cannot sell away the property, because after A's life he is enjoying the property until the A is alive. Once A is he is not alive or he is dead, then he has to transfer absolutely. That means he has to transfer it to C, and C will become the absolute owner or the ultimate owner. He gets the right whether to keep that property with him, whether to sell it out. But the B, right, but the B only gets the property to enjoy that particular property, and not ultimately, he does not have the right to sell or transfer it, right? He has just got the property to enjoy it over till the life of A. right? So remainder is it does not come back to the owner, and the ultimate transferee enjoys the absolute interest over the property. So if he sells his interest, it will be valid so long as he is alive. So after B's death, the property will go to C. Interest is called the remainder. So in case of remainder, property will not come back to the owner, but it goes over to the other person. Correct? Now, second differentiation is in regards to vested and contingent interest. Now comes the another very important differentiation between the vested and contingent interest, right? So the word vested is used in two different sense. It may mean vested in possession or vested in interest. So that means what they are doing is they are bifurcating the word vested into two parts, vested in possession and vested in interest. Now vested, basically the term vested means, or rather I would say vested in possession means immediately transferring the property, correct? So when something is being vested or vested in possession, that means I am getting that property with immediate effect, correct? But when the thing is vested in interest, correct? See, a right is said to be vested in possession when it is a right to present possession of property, and it is said to be vested in interest when it is not a right to present possession but a present right to future possession. Now listen to me very carefully. There are two words used in this particular differentiation. First is vested and the other is contingent. Now vested means either the interest, either something is being transferred to me with immediate effect or something will be transferred to me on a future date, correct? So that is vested in possession or vested in interest. But contingent means that something will be transferred to me or not will depend upon happening of certain condition which may or may not happen. That is contingent, correct? So you must be clear with these two words, that is vested and contingent. So a right is said to be vested in possession. When you hear the word possession along with vested, so that means it is coming to me, at immediate effect. Presently, it is coming in my possession. And it is said to be vested in interest when it is not a right to present possession but a present right to future possession. I will get that possession in a future date. So it is vested. So that is vested in interest. Correct? For instance, if a land is given to A for life with a remainder to B, correct? So A right is vested in possession because he is getting the possession immediately. But to B it is vested in interest. It will transfer to B on at a future date. In the above example, an interest of B is not subject to any uncertain condition. It will come into his possession after A's life come to an end. Write it down as simple as that there is no condition involved in vested. There is no condition involved in vested, right? And what do you mean by a contingent? बोलते हैं interest is said to be vested when it is not subject to any condition precedent. That is when it is to take effect on happening of an event which is certain. Whereas an estate is contingent when the right to enjoyment depends upon happening of an event which may or may not happen. Correct? So that is contingent. Thus, a gift to A on the death of B creates a vested interest that you will get the gift after the on the death of B, correct? In A, even during his lifetime of B, for there is nothing more certain than death. Because see, anybody can say that okay, death is being regarded as contingent. No, it will happen. There is nothing more certain than a death, right? So this is not a condition. It will happen. Now it may happen today, tomorrow, or few years, or after many years, but it will happen, correct? So that is not a condition. So first of all, in when we use the word vested, there is no condition involved in it, right? That particular interest is transferable, heritable without any condition. But when we talk about the contingent side, contingent is attached with a condition and it is not heritable, correct? Now, a contingent interest, as said above, is an interest which takes effect after the condition is satisfied. It is subject to the condition precedent, that is, unless A marries B's daughter, he will not get the property. Property is given to A for life and then to B if he marries C, correct? So, there is a condition. So B should marry C before A is died, then only he will get the property. If he does so, his interest is converted into a vested interest. Before B marries C, his interest is conditioned. Before the satisfying of the condition, that particular thing is contingent. When the condition is satisfied, it becomes vested. So contingent interest is not heritable, although it is transferable. That means you can transfer it, but it is not heritable as in the case of vested interest. So two things, two differentiation we have covered. One is between the reversion and remainder, and other is vested and contingent, correct? Now let's study about the movable and immovable property. So transfer of property does not define the movable property. Therefore, it is said to define with the help of other statutes. That is, it has been defined in the Journal Clauses Act as to mean property of every description other than immovable property, right? So they have given a very layman definition. Okay, what is movable property? So anything except immovable is movable. This is what they are trying to say. So the Registration Act defines movable property to include property of every description excluding immovable property, but it includes standing timber, growing crops and grass, because they can be, um, they can be taken from one place to another, or they can be easily sold out in the market, correct? So movable property is sometimes regarded as immovable. This may happen when a thing of chattel is attached or embedded on the earth. For instance, if the machinery of the plant is installed on the land, the question arises whether the machinery or the plant is movable property or immovable property. So it has been laid that when a particular thing is, being digged up in the earth, right, have been so fixed up in the earth that to move that particular thing, we have to, do lot of effort to make it movable, or it has been so much fixed in the earth that it cannot be taken from one place to another in an easy manner. We will regard it as immovable, correct? But when, a temporary suppose a temporary cement base has been created and a particular machinery has been fixed in that particular base, so obviously it can be taken, it can be, detached easily, so it would be regarded as movable, correct? So immovable property is not defined again under the act. However, it is defined in a negative sense. What they have excluded the things. Their negative sense as immovable property does not include standing timber, growing crops and grass. Why so? Because they can be detached from the land and can be easily taken place from one place to another. Correct? So immovable property, the Journal Clauses Act defines the term immovable property but not exhaustively. So immovable property shall include land, benefits arising out of land. This you need to study very, very carefully. That immovable property includes land, correct? Benefits arising out of land, correct? And the other things attached to the earth or permanently fastened to anything attached to the earth. Say suppose a building has been constructed. Now it has been constructed in such a manner, that a land has been digged out up to a certain level, and from that the base has been structured, right? So that becomes the immovable thing, right? First thing. Now, when a building has been constructed, apartment sort of thing. So in that apartment, we have doors, we have windows that are things attached to the that particular building. So it has been written things attached to the earth or permanently fastened or anything attached to the earth would also be treated as immovable property. So the room in which you are sitting right now must have door or windows, correct? So that doors or windows would also be treated as an immovable property once they are attached that in that particular apartment, right? And benefits arising out of land means that if I own a house and I have given that particular thing on rent, so the the earning, the rental income for me, the rent which I am earning would also be treated as immovable property because that's the benefit which I am getting from that particular immovable property. So land itself, the benefits of the land and the things attached to the particular earth, right, permanently fasten or anything attached to the earth falls under the definition of immovable property. Then, what do you mean by attached to the earth? So, it means which is something which is rooted in the earth, as in the case of trees and shrubs. But timber, mind it, timber is not regarded as an immovable property. Why so? See, because you have seen the furniture being made out of timber wood, correct? So that thing can be, that particular thing can be cutted down and given the shape of the furniture. So it is not regarded as immovable property. Other than that, all trees and shrubs are rooted in the earth, are permanently fixed on the earth, so they are immovable, right? Or they come fall in the definition of attached to the earth. Embedded in the earth, as in the case of walls and building. Attached to what is so embedded for the permanent beneficial enjoyment, right? So things rooted in the earth is trees and shrubs, except standing timber. Second is things embedded to the earth, as in a house being embedded in the earth is immovable property, and this is so even if it is sold, even it is sold for enjoyment as a house with an option to pull it down. The mode of annexion and objection of annexion are two tests to determine whether it is immovable property or not. So here it states that the mode of annexion, that means permanently affixed to the land or on a temporary basis it has been affixed to the land. And the purpose for the annexion determines whether the thing is movable or not, right? Now, attached to what is so the attachment must be, as the section says, for the permanent beneficial enjoyment of that to which is attached, that is doors, windows of the house, movable parts of the fixed machinery, but attachment must be intended to be again permanent, right? So A orally grants to B rupees 700 the right to catch 700 for the right to catch and carry away the fish from his lake, correct? So here is a lake. Now, A has taken 700 from, suppose this is B, right? So, A has taken 700 from B and has given him the right to catch fish from his land, correct? From his lake, right? So, so here it says that is the grant valid? Supreme Court in Anand Bhera versus State of Orissa marked this particular case as important, uh, that such a right is a benefit arising out of the immovable property. That particular lake is immovable, and the fishes in the lake is the benefit which you are getting from the immovable property, correct? Namely, the lake. So, under the Journal Clauses Act, it is immovable property. The sales requires a registered instrument for its validity under Section 54. Therefore, the oral grant is invalid and cannot pass away the title in the favor of B. So here they are not, restricting it altogether, but what they are saying is, okay, if you have to reap the benefits from my immovable property, then you have to get it registered. Correct? We'll see that the transaction or the value of 100 and above needs to be registered, right? So here it is written that A orally grant, because A was orally allowing B to catch fish from his lake. Now lake being an immovable property, fishes being the benefit arising out of that particular immovable property needs registration, because here again the amount involved is 700. It cannot be done orally, correct? So this particular case you need to remember. Now The following have been recognized as immovable property. Mark it as very, very important because these things can be asked in your exam. Just learn it up. Okay, learn it, write it as much as you can. Do the writing practice of these things. What comes under the immovable property, or rather, what are recognized as immovable property and what are not. So, right to collect the rent of immovable property is obviously immovable property, right? Your right is regards to immovable property. A right to weigh, correct? Then a right to collect dues from fair on a piece of land. You have a land and you have, given the right to organize a fair. So the right to collect the dues or to collect the rent from that particular fair is in regards to your immovable property. So that particular right is also regarded as immovable property, right? Hereditary offices, the equity of redemption, the interest of mortgagee, right to collect lac from the tree, right of ferry, a factory, correct, reversion in the property lease, right to receive future rents and profit of land, a right of fishery is what is all these things are regarded as immovable property. Correct. So how many are there? You have 12. So just learn it up. All 12 needs to be on your fingertips. Then the following which have been held not to be immovable property. What are they? Right of worship. Correct. This is not an immovable property. As in there is a temple. Correct. So you cannot say that okay, this is trustee cannot say until unless it's a private thing that okay, that particular temple belongs to me and no one can come to my property to worship. No, the right to worship is not immovable property. Government promissory notes are not immovable property. Royalty, a right to recover maintenance allowances. Copyright, a decree for sale on a mortgage deed, a decree for arrears of rent, right? So all these are not immovable property. So how many are there? This is 1, 2, 3, 4, 5, 6, 7. So 7 things are not recognized as immovable and 12 things are recognized as immovable property, correct? So you need to learn these and they should be in your fingertips. Now comes section number 5 with regards to rule relating to transfer of property, whether movable or immovable. What is the rule which has been prescribed in this act regards to transfer? The transfer must take place between the two living persons only, correct? So in living persons, we include the companies or association or body of individuals, whether incorporated or not. But the main thing is that the person should be living and the transfer and to transfer the property to perform such act in this section, living person include a company, association of persons or body of individuals, whether incorporated or not, right? Now section 6 talks about subject matter of transfer. Obviously it has to be a property. So the Transfer of Property Act states that the property of any kind may be transferred except as provided in this act or any other law for the time being in force. The word property of any kind indicates that transferability is a general rule and the right to property includes the right to transfer the property to other person, correct? So as in it states that property of any kind indicates that transferability is the general rule and the right to property includes the right to transfer the property to another person. The right, the person should have the right, the ownership to transfer it to other person. Now comes a very, very important section, that is section number 7, or rather, sorry, to say the things which are there in section number 6 only, the things which cannot be transferred. So again, mark it as important from the exam perspective that the properties which cannot be transferred, what are they, right? Now here are 6 to 7 things which cannot be transferred. So section 6 of the act contains some exceptions to the general rule that property of any kind may be transferred. We have studied in section 6 only that it has been written subject matter of the transfer. The property is a subject matter and any kind of property can be transferred, but there are exceptions. the following properties cannot be transferred. So first thing is that the chance of higher apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of the kinsman, or any other mere possibility of the like nature cannot be transferred. That means merely based on the pure assumptions that my father has, so much of property, so I being the only heir, or I being one of the heir, will get that property. So I am basically assuming things, right? So based upon those assumptions, I am, today only entering into an agreement with other person, transferring those property, that they will come to me, that property will is belongs to me only, I am the sole owner. After my father, I will only get that property. So presuming things, I am entering into I am entering into a deal with other person, basically transferring those property. I cannot do so because I do not know whether the my father will give to me or to anybody else. Correct? How much share I will get, or how much share, or in what proportion it would be distributed. It may happen that he does not give any share in the property. Then what will happen? So, until unless you get the possession, or you get the things in transferred, you get the things transferred on your name, until that you cannot enter into further, transactions with anyone to transfer the property, just merely based upon pure assumptions, right? Second is a mere right of re-entry for breach of condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. A mere right of re-entry for breach of condition. Say suppose I own a flat, right, and I have given that particular flat on rent, and the tenant and the owner, I have entered into an agreement that that particular tenant would not, sub rent it, right? Would not, or say suppose will not use the property for commercial purpose. We have entered into an agreement. Now the tenant is, breaching that particular condition. He is either using for the commercial purpose, which was strictly being prohibited, restricted, or he is further subrenting that premises, and I as a owner comes to know about this, so I have a full right to re-enter into my property. Correct? But it is written that except the owner of the property affected thereby. That means if this the particular thing has been sold to that person. Say I owned a flat and I sold it to Mr. B, and he has paid me the consideration. Now he being the owner can do anything upon that. But before that thing, if the property is not being sold, or it's just given on lease or on the rent purpose, if the tenant, if the lessee is breaching the condition, I have the whole right to re-enter into my property. Correct? So the things which we are studying is the properties which cannot be transferred. First thing was the thing which are not on my name. Just on the presumptions or assumptions, I cannot transfer that now, right? Second is a mere right to re-entry for breach of conditions. Subsequent cannot be transferred. The thing which I have not got, how can I transfer that? Correct? So that is also not allowed. Third is easement cannot be transferred apart from the dominant heritage. Say suppose this is a house, correct? And another house is this one. Now there is a road going this like this, right? Like this. So there are only suppose two houses. The first is this and the second is this. Now, to come to this particular place, I have to cross this particular area which belongs to the owner of this house, right? So, this is the dominant heritage, right? To reach to the dominant heritage, I have to pass this area which belongs to some other person, correct? And if I am transferring, if I am selling this house, then naturally I have to, that, it's the things which, goes without saying that obviously if I'm selling this house, the person who is buying this house will also come from this way only. So he gets the right automatically to reach that particular house from this way only because there is no other way, right? So it is being said that if you are selling the dominant thing, dominant heritage, then obviously the easement, right, this thing automatically gets transferred. But without selling the dominant heritage, I cannot, give the right to use this particular area to any person. I cannot sell this particular, I cannot transfer the right to use this particular area to other person without transferring my dominant heritage. Correct? So there was only one way reaching to that house. If I have to reach that house, I have to follow this route only. There is no other way. So that goes by default. If I am selling that house, and obviously the right to reach that automatically comes with that, sale only. But without selling the dominant heritage, I cannot sell this particular way to anybody else, right? Because it does not belong to me. Correct? Second, an interest is property restricted in its enjoyment to the owner personally cannot be transferred by him. That is, an interest in the property restricted in its enjoyment, the thing which, has been specifically restricted, right? I also does not have the right to use them or to enjoy them. Obviously, I cannot transfer it to somebody else. A right to future maintenance in whatsoever manner arising, secured or determined, cannot be transferred. Say, suppose um, through court, a particular person has been given the order by the court to pay the monthly maintenance to his wife, right? So this has been assigned to the husband, so he cannot transfer his right to give future maintenance to anybody else. He cannot do so. A mere right to sue cannot be transferred. That means if, if somebody or something gets, if something wrong is being done and that property belongs to me, then I only have the right to sue against the other person. Nobody else can sue in behalf of me. Correct? So right to sue cannot be transferred. Then public office cannot be transferred, nor the salary of the public officer, whether before or after it has become payable, cannot be transferred. See, if somebody is a government employee, then he cannot just transfer his position to anybody else, right? He cannot just transfer his salary to anybody else's account. After he receives, he can distribute the way he wants, but he cannot ask another person's bank account and, directly giving his salary to that person's account, right? Stipend allowed to military, naval of force, civil pensioners of the government, political pensioners cannot be transferred. So these things you have to remember, by heart, that what things cannot be transferred. Basically, remember this way: the things which you don't own by yourself, you cannot transfer, right? Merely on the assumptions. Correct? You cannot transfer the thing which you do not have the right to enjoy. You cannot transfer that. Without transferring the dominant heritage, you cannot transfer the easement attached to it, right? Then right to suit cannot be transferred. Public officers cannot transfer. Can public office cannot be transferred, not the salary of the public officer. Stipend allowed to military, naval forces, civil pensioners of the government, and political pensions cannot be transferred. Correct? Then what else? The right to maintenance, right? It has been written that a right to future maintenance in whatsoever manner arising cannot be transferred. So just, see the videos, understand it, and then try to recall. Okay, in this topic, ma'am has taught these things. I know what point you are able to recall matters a lot. Just, going through the videos, very in a very quick manner, studying, going through all the notes, and, being being very much satisfied. Okay, I have covered everything. No, it won't help until and unless you, just if you recall. If you are not able to recall things, nothing will help you. So try to study in a shorter manner, right, for shorter duration, but try to recall as much as you can. This only can help you and take you further in the long run, right? Then comes who can transfer the property. So from this particular heading, we will start from the next class, right? Next class of the Transfer of Property Act. I hope you have understand the basic concepts, really enjoyed the class, and whatever doubt, if at all you have, you can ask me, you can WhatsApp your queries and you will get the reply within 24 to 48 hours. But I always say do the writing practice, solve the scanner's question as much as you can. See you in the next class. Till then, take care.